Well, what we'll do is we'll start right away. It doesn't matter how many people are in the room, so long as we are on time, we will start on time. This particular session is on trade secrets and the way forward. Keeping in mind, and we'll try to discuss this subject in the context of various sectors, in industry and otherwise. So if you look at the whole area of trade secrets, right, certain countries, please come, certain countries have laws, specific laws with regard to trade secrets. Certain countries do not have those laws, like India does not have a specific law on trade secret. But nevertheless, it's still being practiced. So what we need to do is to look at all the dimensions of trade secret, take a 360-degree view, and then try and see or conclude from there what we should be doing as a country in terms of policy, what's the approach that we should be taking. And therefore, to do this particular, to have this discussion, we have an excellent panel with people with a lot of experience in industry who are practicing these things day in and day out. So we have Vivek from Roche, obviously from pharmaceuticals, and has been practicing as an IP expert for Roche for several years. We have Chitra. Chitra also comes from the pharmaceutical and chemical sector. She has also about 2 decades of experience of working in this particular field. We have, Vyas, Garg Vyas, coming from an engineering background, Cummins, and so we'll have a perspective of that sector as well. And then we have, Tuhin, where he will come in from the aspect of packaging, new materials, and innovative solutions. So we have a spectrum of sectors to look at, and therefore, without going into too many details of introduction, which is already there in your books, so we won't go into introductions of the panelists, we will straight away approach the subject. And what we would like to do is we will have a discussion first within the panelists for, let us say, about 30 minutes to 35 minutes, and with about 10 minutes for an audience participation, both in terms of questions and in terms of what I would say comments, if any. So, so if we go across to the subject proper, what I would like to do is that the first part we would like to address is when we are filing patents, it's a disclosure. Trade secrets is about not disclosing. So we want to take the first round of discussion on what are the essential factors of disclosure and non-disclosure. And so for that, I would invite Chitra to start off, her perspective on how she looks at this subject. Chitra.
Thank you, sir. There is a saying, if you are given 8 hours to cut a tree, spend the first 6 hours sharpening the axe. So before filing any patent application, it is necessary for us to strategize what needs to go into a patent and what should not be present as a patent application. That is the reason that it is possible to manage both trade secrets and patent together. Each are complementary and has to be done together. So what are the steps and how we need to think about it? I am borrowing from Dr. Ganguly, one of the terms he used yesterday during our discussion, designer patents. In other words, these are patents which are designed in order to adequately give the best disclosure of the best mode and also hide something that we can retain as trade secret. All of you know what this trade secret is, but it is not exactly same as that of a confidential information. So it needs to have some economic value that you need to hold it as a trade secret. So for instance, when I'm drafting a patent application, it is necessary as per law to give the best mode. So when you are giving the best mode, just to keep it as a trade secret and you want to hide the best mode, it's not a good idea because your patent will file in the working. That becomes a huge problem. So what do? You keep as trade secrets certain critical steps, which steps still have, the best mode, but which will not lead to the process being manufactured in full. I'll give you certain small examples. For instance, when you do a cell line, there are some additions of reagents. Certain reagents has to be added at 4 degrees centigrade and certain reagents have to be added at 25 degrees centigrade. So you don't tell which has to be added at what. It is still a workable range, it is still the best mode, but you have not given which temperature or which reagent needs to be added at what point of time. So when you have built in such information during the trade secret, it becomes very important for us to identify it as a trade secret, keep it limited access to certain people, and ensure that it does not get out. After filing does come prosecution. I see that many attorneys, just to get a patent grant, give extra information which has been qualified as trade secrets. Now there is a mistake in 2 parts. One, the company who has not informed the attorney that this is a trade secret and should not be given during prosecution. And the second, the part of the attorney who should be able to get a patent based on the information disclosed in the specification. Otherwise, if you disclose too much, you risk, getting a patent but losing a trade secret. It is similar in an opposition. Even when there is a third-party opposition, which is in different forms in different countries, you should know how actually to do it. We did an opposition for one of the pharma molecules called daclatasavir. When we did for daclatasavir and we wanted to file affidavit, we clearly told the patent office, this contains some amount of trade secret, so it has to be given only to a certain person in the opponent. Or in other words, we utilize the presence of a confidentiality club, which ensures that only certain members of the opposition team or the certain members of the other team will get it. It can nowadays even be built into contracts to say that if, for instance, I have to disclose any legal information, that legal information can only be accessed by perhaps a CTO or perhaps the CFO or other people and build in other confidentialities. So it also starts with contracts to show where and how the disclosure can happen. And if we do all this and still manage to maintain it as a trade secret, that is when you can claim the premium in licensing. When you license it out, even then you have to be extremely careful as to how much is given in the license, and anybody you are licensing is also bound by further confidentiality contracts.
Great. So now the important part is the disclosure required under Section 10 of the Indian Patents Act. I'm talking about India at the moment, right? So there has to be adequate disclosure, right? Number one. And number two, very important for us, that we are not divulging in the patent specification commercial information. What we are doing by way of examples is illustrating the best mode. So our best mode is coming via the examples in the patent specification. That's basically that I'm saying, let us restrict to that part in a patent. The rest we shall keep away for the time being, and we decide how to strategically use it as and when we want to work that particular patent in a commercial scale. Now at this stage, I'd like to invite Vivek, how you look at it coming from Roche and looking at it globally, how you look at this particular thing in different jurisdictions and what sort of care do you take while filing your patents?
Thank you.
And keeping trade secret in mind.
Yeah, thank you, Professor Ganguly. Good morning, everyone. Sorry, good afternoon. Before I actually go into the facts on, how we handle things on trade secrets at different jurisdictions, maybe it is very important, and I'll pick up from where Chitra, started, specifically because you need to first understand the basic fundamentals, and these fundamentals are, information being disclosed in patents versus information being looked from a trade secret perspective. See, when anybody starts the discovery of a drug, it is not a drug at that point of time. It's a molecule. And you file patents at a stage when you just have handful of molecules or few hundred molecules. And you don't know at what stage or whether one of those molecules or few of these molecules will get converted into a drug and you have a successful drug. So that is one of the important points one has to understand, because when you are filing a patent, you are in a very early stage of discovery and you just know what molecule you're talking about or what molecules you're talking about, and at that stage you have a very limited information, which is mostly lab generated or a preclinical stage information. A lot starts developing once the molecules goes into the clinical stage, the manufacturing stage, and that's where the real importance and value of trade secret would come in. Specifically because as Chitra gave examples of cell lines, the cell lines at 4 degrees would be probably at a different stage of development. Cell line at 25 degrees or the regions used at 25 degrees will be at a different stage of development. You might disclose something very broadly, basic fundamentally in the patent application, but what happens at a later stage is very difficult to predict. You can file patents for that, that's one part of it. But what happens post the discovery of the molecules is much more, and that's where the trade secrets plays a very, very important role, because it's all about the material being used, the temperature being used, the access, the increasing the manufacturing, the commercial level. Requirements are very, very different than at what is the requirements of the patent stage. And that's where the trade secrets become very important. And it cannot be disclosed. When it comes to practicing trade secrets in various jurisdictions, while we know that in India we don't have a trade secret laws, what we look into is primarily there are various stages where these informations are kept confidential, specifically the provisions which we have implemented in the organization across the affiliates. That's one part of it within the internal processes. Then while we implement these processes of trade secret protection, we also look into the local provisions, legal provisions which may be there in US and Europe, and see how those can be incorporated while dealing with trade secrets. There is always the agreements which we are talking about, the licensing agreements which we may talk about, may be very general. But then those licensing agreements have to rhyme with the local provisions in US, in Europe, and wherever these trade secrets are. Europe doesn't have that, I think. US does have. And then there are gatekeepers for these trade secrets. Not everybody needs to know all the information. And these gatekeepers ensure that people are decimated with necessary information only from the perspective of need to know. And that's how it goes about it. Primarily, the trade secrets issues come and are considered when the molecule is in very advanced stage of development and has reached probably the manufacturing stage, which is a very important critical stage, which cannot be sometimes captured in a patent application because there are various factors. You know, for example, you're talking about the quality of raw material. Where is it coming from? Who's manufacturing it? The process of filtering mechanisms. It may be very common knowledge, but how you use it, where is it being used, what steps they are being used, how is one organization using it. All these matters are very important. And then, as I said, there are internal controls where we keep a very tight control on the fact that who has this information, how we store this information, and how we decimate this information. And these are all laws protected.
So now coming to another sector, and that is to the engineering, communications and all that, where the life cycle of these technologies, now here was something where, you know, the life cycle is long. We are now coming to technologies where the life cycle is very short. So the question is that in those sectors where the life cycle is very short, how do you handle the balance between what you would patent, what you would keep as trade secret, and what you define as trade secrets in your area?
Thank you so much, Dr. Ganguly. Very, very important and very, very critical aspect you have highlighted here. So I'm basically from Cummins. Very small disclaimer, whatever views I'm sharing is my own. When we talk about automobile, we generally have a saying. Earlier it was 80% mechanical, only 20% electronics. Today we have more than 80% electronics, software, and hardly 20-30% is what is a mechanical in any vehicle. We have 360-degree cameras. We have telematics. We have all the digital screens, touch screen, Apple CarPlay, and so on and so forth. And if we talk about all this together, I'll go a little back before patenting. Innovation, a very heart of any organization, especially like us or even, you know, my friend Vivek in Roche. Innovation plays a crucial role in growth of an organization. Who does innovations? Engineers, researchers, scientists. Today we are talking on such a heavy topic like trade secrets. Does innovators know what is trade secrets? What is the difference between trade secrets and patents? No. Do they know what to share and what to not share? I tell you, in telematics regions, the way software, you rightly said, Dr. Ganguly, you know, we are, processing at a very fast pace. Earlier, one engine has been developed, one IC engine has been developed with, let's say BS3 or BS2. That has stand for ages. Then BS4 came. But see the leapfrog, even India is taking from BS6, BS4 to BS6, and now we have already started under this government about BS7. We have already, our, Transport and Road Minister, Honorable Minister Nitin Gadkari traveling in a hydrogen car. So see how we are leapfrogging in the technology space, how fast we are leapfrogging. In that scenario, the overall life cycle of an existing version, I will specifically use the word version, is very small. And in those scenario, if we take minimum time of filing of patent to the get a grant, let's say 2 or 3 years, I mean, my technology is already gone. It's done and dusted. So that's, where we have started to seriously think about whether to invest a lot of money into patenting, or is it right to protect some critical aspect of those technology under the trade secrets. Now here also I want to add one more point. Why I emphasize on the inventors, engineers and researchers, and they are knowledge restricted on those aspects. Why? I am coming from the sector where lot of inter teams, play a crucial roles. Maybe my designers have designed something. Then it goes for the simulation. The simulation team is altogether different. Knowledge has been shared from a designer to the simulation team. Then it goes into the testing and validation. That's altogether a different department. Knowledge has been now shared from design to the simulation to the test and validation. So the knowledge, know-how is traveling from this. Once it is test and validated, it also goes to the supplier for the field trials. So till now, my knowledge has only traveled within the organization, from the designer to the simulator and to the test and validation. Now it is stepping out of the door of my company to the suppliers for the field trials. After that, the prototype will be built. I don't know which department it will be involved. And once the prototype will build, the business will discuss. So imagine a technology, know-how, knowledge is traveling for so many departments, not only within the organization, but outside. And then the question comes, how best we can protect the trade secrets within these departments, outside the organizations. So that is where I think today's topic plays a very critical role. Especially you started very well, Dr. Ganguly, I would like to say. You said about there is no law. I'm coming from an organization. We have, R&D setups in US, in China, in India, in European countries, and so on and so forth. US, a very well-developed economy where there is a proper law for protection of the trade secrets. India, a little bit of China. If we say Southeast Asian countries, we don't have any law. We don't have even a statute directly to protect the trade secrets. Imagine how complex it is for us to put a boundary wall around such technology which we like to protect under the trade secret.
So now coming to Tuhin, who comes now from a completely different sector. And in this particular sector, apart from things being fast moving, right, it moves from department to department, from organization to organization, because they are providing solutions. So they get problems, they create solutions, they offer solutions. So they have many more stakeholders. So the question is, when you deal with multiple stakeholders, how do you handle your trade secrets with respect to multiple stakeholders?
Correct. So that's a very important question for organization. The decision making in two ways. One is how I protect through patents and how I protect through trade secrets. That decision making itself is a very complex one, and it's contributed by different parameters. Apart from the nature of the inventions to the business model, the competitive activities in the market, the cultural upbringing of the organizations, and the different process and policies that are put in place. So I think the most important is to look at the innovation or invention as invention. So understand what is the point of novelty. Is there a point of novelty? If there is a point of novelty, would it give me some right towards a patents through meeting the legal requirement of inventive step or non-obviousness? Sometimes in nowadays, every field of technology is getting matured. So everything is matured, the material science, the mechanical science, automobile, everything's getting replaced by digital technologies. So now the systems are system of systems. Something comes from the physical side, something comes from the digital side. You develop technology in California, you deploy the technology in multiple other parts of the geography, where the laws are different, the people who are handling the technologies are different, the cultural upbringing, what I was telling earlier, and the culture around production is completely different. There are different teams, as Garg was mentioning. The internal teams, there are teams from the suppliers, there are teams from the end users. There are a lot of teams involved. There is free flow exchange of information. The tussle happens that R&D wants to spend time on protection, base protection, but the marketing and the commercial team, they do not want to wait. They always want to go fast and start deploying and start monetizing the technology. So here the roles of the IP attorney plays a big and very crucial cultural and advisory role for our organization as to how to balance the conflicting demand within the organization. One is from the marketing and commercial side, one is from the R&D side. So, and it is very dynamic. You really need to understand all of those factors, your business model, what is the nature of the technology in the sense, it is a matured one or is it nuance, it's just, in the embryonic stage, it's going to take off and then it at least leave 20 years, 25 years before it can mature. So I think all of these put together, gives a lot of information as to what kind of technology would go for patenting and what kind of technology would go for.
So now the next part, which becomes important for us, because when we are talking about something called intellectual property, and if trade secret is an intellectual property, the question is, who owns it? And therefore, the parameters that are important, that decides on who is the owner, becomes very important. And therefore, my question to the panel, starting right from you, a couple of sentences on what you think are the parameters that determine the ownership of trade secrets. Because at the end of the day, if you want to enforce, the owner and the ownership has to be, first fixed. Only then can you go to the next step. So just a few sentences.
So maybe I'll just start. Since we're organization under US law, so we follow that there has to be some mechanism to keep the information as secret, reasonable effort to keep the information secret. It could start in various facets, for example, employment agreement, specific employment agreement, contractual obligation, assignment of the right. If it is through merger and acquisition, it has to have a stipulation of the trade secret in that agreement. And then the electronic and physical means. And sometimes we also use what is we call FMEA, failure mode effect analysis, which often utilized in operational terms. How do you mitigate the risk associated with the process of divulging information, maybe within or maybe with any collaborator? So how you score, how you assess your RPN, risk mitigation number, what risk is acceptable, do you have documentation, it is approved by the management, do you have record, have you cataloged your information, who are the members of your team inside and outside who has the approval to access, and what amount of access is necessary for the business tasks to be accomplished. So I think these all kind of record can help for when we go for enforcement in the court of law.
Coming to you, Garg, the point is that assuming, I'm making an assumption, assuming that you know who the owner is in your organization, right, of the trade secret, what I'd like to ask you is that you know that in India, right, we have the Constitution of India. And if you go to the Article 19(1) of the Constitution, right, that's one part of the story. Second part of the story, which is linked to it, is the Contract Act, right? And we have a pretty archaic Contract Act of 1872. Right? On one side, we are abolishing Article 370, but on the other side, we have kept a Contract Act of 1872. So how do you look at your contracts, your things, and bring this whole concept of ownership within the organization?
Before I jump into how the contract should be managed within such within such organizations of automobile and all, I would like to highlight one particular case, interesting case of Tata Motors versus State of Bengal. I think it goes way back in 2008, where the per se definition of trade secret, Honorable High Court has to take, I think, from Black's Law Dictionary. So imagine we don't have a law, trade secret law. We are highly relying on the age-old, contract tax and some other things. So I think that's where it is very, very critical and essential that what goes into those agreements is highly important. What are we keeping? How are we keeping? Confidentiality properly defined, whether it's a technology know-how, whether it's a process or a product or only a technology. Everything has to be clearly kept on the or properly defined in the contract. So that is very critical. Also the standardization. That should not happen. The same format or template in the contract, deals separately in India and deals separately in US. Of course, it should be aligned with the respective law of land, but that doesn't mean the very nature of definition is different. That cannot be acceptable. And that's where, the very reason for highlighting this is, in this particular case of Tata Motors versus the State of Bengal, the very nature of definition of trade secret, it has to be first of all kept such a way trade secret and very important to the organization and having economical value to it. So these are some of the critical ingredients when we are defining something as a trade secret or a confidential. Especially in a law of land, where you rightly said we don't have any law or a statute around the trade secret, and some of the laws which are protecting around are way old, or I would say need some amendments. So I think that's where it is crucial.
So coming to Vivek, so coming from one of these organizations, what you recommend as the best practices organizations should follow to protect trade secrets?
Thank you. Okay. First of all, there is no best practice. I mean, from a larger perspective, if I may put it. Tuhin has already kind of captured very broadly that, how the contracts, agreements between the employee and the employer needs to capture important aspects of the employer's role. That's one part of it. The second part of it is that how do you ensure that, I mentioned about gatekeeping, and that's very important. When you're talking about gatekeeping, it is very important that everybody need not know about everything. There has to be a line drawn, and you need to capture who needs to know what information for what perspective. A third thing, which is very important from my perspective, is that sometimes everything cannot be captured in an agreement. Therefore, whatever discussions you are having, whatever meetings you are having, you need to keep a record of that, because those records can sometimes be very, very important as an evidence, which may not be captured directly or indirectly as part of the agreement. And Tuhin did talk about it, but I think what is happening, what the biggest challenge which we are seeing nowadays is when people are working remotely. Post-COVID, we have seen that. You have people working remotely, therefore your systems needs to be absolutely secure. And usually the organizations have these secure system on which discussions, meetings, PowerPoint presentations, agreements are shared and captured and stored. Another important point which has to be looked into is when you're working with a third party, how do you capture these contractual agreements with respect of trade secrets? Especially, when you are discussing certain aspect which may be of importance of trade secrets, and therefore something new may come up and can be used by a third party. And therefore your initial NDAs plays a very, very important role in capturing all information relating to the trade secrets. Though it is very difficult. That's why I said there is no set rule. There is no best practice. It has to be individual organizations need that defines the best practices, and those best practices need to also capture the local laws if they are prevalent, directly or indirectly. Like for example, in India, we don't have a trade secret law, but there is a need of it. But then there is a contract law, and therefore it has to kind of come within the scope of that ambit, so that when you kind of want to enforce it, you are able to not only enforce it, but also prove that who has the right over that trade secret or innovation which has originated.
Just one small input here, that intuitively we might believe that trade secret threat happens through some sophisticated and cyber crime or cyber security breach or something of that sort. Very, very spy intensive process. It's not. So most of the time, I mean not most of the time, the strategy says that 90% of the cases, the trade secret threat happens within. So your internal people are responsible for divulging information, taking the information outside. So that's a big, big, kind of attention that every organization need to put.
Yeah, okay. So that's a very important point when you mentioned. Let me give you a very interesting example from pharmaceutical industry. So it happened in one of our affiliates. So there was these individuals who were, I would say, who was working with our organization, one of the affiliates. And that person happened to kind of share this information outside to a third party through her husband. And we were able to prove that how this information was leaked out and shared to a third party. And the way we could do it, because we had records for it. There were communications, there were indirect means of capturing that information that was leaked out. So exactly to the point what Tuhin had said.
I'll just add a very interesting actual case, which was there, and I was a part of that. So without naming organizations, the two major organizations I'm talking about, very major, right? All of you know about them, so I won't talk about the names. I'm not allowed to. But one organization came in and contacted the cleaners of the other organization, right? And what was the thing? They said, these people, all you do is when you take the waste paper baskets, bring all the stuff from the waste paper baskets to us. Now what you put in the waste paper basket is a lot of information which you don't think is very important, but they are very important. And it was found out that suddenly the organization, the cleaning was very efficient. Somebody noticed it. Said, what has gone wrong with the organization? Why is it so efficient? So there was a due diligence done. We did a due diligence on that. And it was found out when these cleaners were confronted where this was going. The idea was that there was an information security policy in the organization where all these things were to be shredded and then going into the waste. But you were putting big pieces of paper inside. So there are leakage of trade secrets even that way. But coming back on track, the important part therefore comes in is the whole issue of misappropriation of trade secrets. So what leads to misappropriation and what are those various implicit and explicit factors do you think we should take into consideration while looking at misappropriation?
Misappropriation can be at two levels. It can be between, organizations. It can also be at individual levels. While, as the statistics says, individuals are more 90%, it doesn't outrule that organizations do not misappropriate at all. When an organization misappropriates, it falls under the competition law in India. And the competition law clearly at section 3, gives a lot of exemptions for intellectual property rights. Surprisingly, now in the Commercial Court Act, which is at 2018, we have also, excluded trade secret as one of the form of intellectual property rights. And therefore, under competition law, it is very difficult to enforce between organizations unless we actually are able to trace the trail of trade secret passage. But when it comes to individuals, it is a little different. In individuals, there are many trade secrets which are associated with different forms of IP. There is a recent case law in 2020 of Professor Claudia D. Simone versus Actual Pharmaceuticals. In this, there was a gentleman who has given a license to one of the Indian companies to make a consortium of microbial bacteria. Unfortunately, he did not have any patent in India. But he had a patent in US, which expired in 2015. And along with that, what happened is our Indian gentleman or the company was able to reverse engineer and arrive at those microbes. But the court very clearly ruled that it was not a trade secret because it is nothing but the best mode of the invention which was disclosed in the patent. While this issue was, discussed in this, it also discussed that there was a trademark and the trademark was being infringed. Okay, and the court said that a trademark is not a public right, okay, and you as an individual is not allowed to, press it as a trade secret or in this particular manner. You have to choose a different forum and a different set of arguments to enforce your trade law. Now, there was one more case law, but not on this, which is based on copyrights, which is based on Navigator Logistics versus Kashyap. Here, the case law pertained to transfer of information which belonged to customer databases, account details, drawings, financial information, administrative information, etc. Here again, the court ruled that, see, a copyright has to clearly identify an author. When the author is not identified and it is not restricted, it cannot be considered as a trade secret, and therefore it becomes very difficult. But there are also cases where, actual enforcement has been done to a very great extent. There was this there's this case between Orchid Pharmaceuticals and Aurobindo. What happened is there was this gentleman who resigned from Orchid Pharmaceuticals, stating many things that I am not going to be here in India, I am not going to practice in this field, so on and so forth. There was a cephalosporin antibiotic in which, there was a solvent system which could be used in conjunction, and that solvent system led to a very great yield and very less impurity. This gentleman, against all his employment contract and his resignation letter and an emails, went and joined Aurobindo. And in Aurobindo, they filed a patent application in US with the solvent system and with this gentleman as a single inventor. So Orchid was very able to clearly prove that, this is a trade secret, there's a single inventor, there's no other contribution, and there are his lab notebooks, and in resignation, he very clearly stated that this information will not go out.
So coming back, now, therefore, very important aspect is employment contracts, number one, and number two, very important, that when people leave the organization, the documentation of the exit interviews become very important. And there was structured exit interviews are of great relevance. Garg.
Not only on the employment side, we also talked about the third-party suppliers, customers. So those agreements also play a very crucial role. Here I would like to highlight one, case law of United States, Eagle Harbor Holding LLC versus Ford Motor Company. So there, I think Eagle Harbor has filed 11 of its patents and filed a lawsuit of around US $750 millions on Ford Motor, saying that, you guys are infringing on us. When Ford Motor did a deep dive into that case and identified that Eagle Harbor has captured all the technological innovation related to those 11 patents from one of its supplier and filed those patents. Ford Motor not only won the case against Eagle Harbor on claim rejection against those patents lawsuit, but also filed a legal lawsuit on the infringement of its trade secrets, and that also has been given favorable judgment in favor of Ford Motors by Western District Court of the Washington. So yes. I think this is a very, very crucial. Of course, the employment agreement, I totally agree. But apart from that, also when we are dealing with a third party, those agreement has to be also foolproof and strongly built around.
Before we go to the last point, in my experience over the last 40 years, consulting across different organizations, today in the pharmaceutical area and in automobile area in India, practically everybody has worked for everybody. It's very interesting. I go to this company today and go to that company tomorrow. I find these people here and those people here. So here practically everybody has worked for everybody. So now how do you, so there's complete democratization of information, of people. But should there be democratization of information? The answer is no. So handling this is becoming an issue. So this is a subject which is of immense importance. The last point which we want to do, somebody is flashing the light, the time is over? That's a new way of telling you the time is over. But anyway, I've got the signal, but just a last point. Now coming to the most recent issues of chat GPTs and artificial intelligence coming in. Each of the panelists, couple of sentences only on what you see as the future of trade secrets with all these new dimensions that are coming in. Couple of sentences.
I think the protection mechanism and tools and the laws that are available today is going to change quite a bit. But one thing that can remain constant and the organization and industry can rely on this is that limit your disclosure. Understand how much disclosure is needed. Oftentimes we do unlimited disclosure. We don't need to disclose certain things, but we keep doing that. Maybe through our marketing people or some people in R&D and product development. But limit your disclosure. I think that's because the way the AI is scraping website and learning, it can, do anything.
Yeah, thanks, Tuhin. And I think we are a generation which are very lucky. We are undergoing a huge revolution itself in the technology domain itself into so many things. And I think I see, apart from what Tuhin has said, is lot of changes and upcoming of new laws as well as amendment of the existing laws. That will be a big game changer also for such issues, as you said, ChatGPT, which see no boundaries, no jurisdiction limitations. I think there government also has to closely collaborate with each other and play a crucial role.
First, I think we should sort out the ownership issue of who will be an author when there is a chat GPT or AI before we even go to trade secrets. And one more tangential answer, in the words of Khalil Gibran. If you tell the wind your secrets, if you tell the wind your secrets, you cannot expect the wind to not share it with the trees.
Thank you. I think I mostly share, the thoughts of my panelists. And therefore, I think the most important thing is that we need to think about having a legislation on trade secrets in India, especially from the perspective that India is looking out for, investments in India. And it's not only for the perspective of big organizations or innovator organizations, but also locally for MSMEs who rely heavily on these technologies, trade secret technologies, because for them, these are the prime important things from the perspective of protecting their intellectual property. And therefore, while we are talking about trade secrets, but I think the point like chat GPT and all these artificial intelligence we are talking about, these are the technologies which are of next generation. And it is very important that they be captured and the issues regarding that be addressed as early as possible by whether in the existing law or whether the amendments of the laws or bringing in new laws from that perspective, because that's actually is happening across the globe.
So just a last sentence, and that is, see, having heard all my dear panelists, at the end of the day, what is it, where do we end the whole process? Number one, you have to learn to keep your secrets a secret, value them, and trade when it is required with your trade secrets. So that's why it's trade secret. Learn to trade with your secrets, but first keep them as secrets. Thank you very much.
Thank you so much. Excellent merger of trade secrets, patents, case laws, even trademark, copyrights, employment contracts, third-party agreements. You mentioned everything. Beautiful. May this echoes of this session resonate in your patent filings, in your regular dealings at your industry level. Appreciation to the esteemed panelists for contributing to the depth and richness of this session. Gratitude to our adept moderator for steering the ship and ensuring a smoothful, insightful conversation. Thank you so much. The moderator. Thank you. Thank you, sir.